What is an immediate possession bond? Well, this refers to a section in the Texas Rules of Civil Procedure that allow for a landlord to post their own bond. I'll tell you that this is not something that commonly happens, and there's a reason why it's not very common, but it is something that you could do if you wanted. For those of you who are interested, I'm going to talk a little bit about what it is and how you would get it. So an immediate possession bond is a bond that's paid by the landlord at the time of filing or any time prior to the date of judgment. So the landlord is paying this bond into the court in order to seek immediate possession, but it's not immediately upon filing, or if after filing a bond is paid, it's not immediate then, it's at the time of trial. If at the time of trial a bond has been paid by the plaintiff, the landlord, and the tenant fails to appear and therefore loses their case by default, it is possible at that time for the landlord to recover immediate possession. However, there's a couple of caveats to this that might make it not so attractive. The first of which is your bond has to be paid by you, the landlord, up front. And the intention of the bond is to protect any tenant from potentially a bad or an improperly filed eviction. If it turns out that there was something improper that otherwise wouldn't entitle you to your eviction, the court can issue that bond directly to the defendant because you filed improperly. Maybe your notice was wrong, or there was some other procedural error on your part for the defendant having to show up. If you cause harm to the defendant and the court sees that harm was caused, the amount that you paid into the bond goes to the tenant. The other issue is that the thing can be undone. All the tenant has to do is show up at the time of trial. And so if you have a tenant who's going to contest the eviction anyway, it doesn't help to have the immediate bond. If you have a tenant who isn't going to contest the eviction, then you weren't going to have the trouble. They're probably going to move out before the date of trial. In fact, most tenants do not contest their evictions, and most tenants move out at or around the time of trial anyway. So while it might buy you a few extra days, you don't have to wait out the 6 days the court normally has you wait after the judgment. Please note that if there's a procedural error in your eviction, or if the tenant simply shows up and submits a written answer to the court or just comes up to testify, it's really not going to gain you very much at all. They'll still be able to file an appeal. And that's the final thing, is the defendant is still going to be able to appeal the case. And if they appeal, what happens to the writ that you were issued? Well, it's subject to a quash, which means that the same court that issued it could say, well, they've appealed now, and so now we're going to withdraw the writ of possession. So this is not something that I tend to recommend to landlords because of the risks that are involved and because of the upfront cost to the landlord. Remember that the bond that's paid is not some established number in the code. It actually has to be approved by the court. And different counties and different courts will set them, based on the individual facts of the case. But the court could set an unreasonably high bond that if you're willing to pay, again, you might risk losing if there's some kind of impropriety in your filing. So as far as me recommending the immediate possession bond, that's just not something that I tend to recommend. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing.